Oh yay, oh yay, oh yay. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. You may be seated.
Good morning, all.
Good morning. Good morning, Dr. Von Gernot.
Good morning, Mr. Schachter.
I have a few more questions that I have to ask, and I guess let's start with this one. You would agree that members of the same cultural group can have common cultural traits even if they do not share the same religion? Would you agree with that?
Yes,
Can you turn to page 25 of your slide deck for the perspectives report? As I read slide 25, I read it as though you equate Dr. Dribbin's use of the words children as assigning to them the characteristics of being immature and or underdeveloped. Is that a fair characterization of how you perceive Dr. Dribbin's use of the word?
yes, the impression I had from reading his testimony was that the use of the term, the kinship term, children and father to the Anishinaabe somehow represented a metaphor, if you will, or a feeling that the Anishinaabe understood themselves to be the father's children and required assistance from the father until they were developed to the point where they could assist themselves and hence get out of this dependent relationship.
Would you agree with me that characterizing children as immature and undeveloped is not an ethno-historic use that Dr. Dribbin was making, but what is a modern day construct of the word child? Are you having
Well,
trouble with the question, or
yeah,
should I rephrase it for you?
If you could rephrase it. that would
Sure.
help.
Maybe I'll put it more directly. I'm going to submit that you know that Dr. Dribbin was using the word children in describing the Anishinaabe in a very culturally specific way in order for him to explain the nature of the conduct expected as between the Crown as fictive father and the Anishinaabe as the Crown's red children. Wouldn't you agree with that?
Yes.
Thank you. Let's turn to human universals. In your direct testimony, you talked about human universals. Now, as I understand it, and I've read Mr. Brown's 1991 book on human universals, you cited it, footnote 58 of your perspective report. If there are universals, can human universals be used by the judge in this case to help her fix the common intention of the parties in 1850? Is it of any benefit to her?
It is a benefit in a general understanding of human behavior, but it doesn't lead us to the level of specificity that's required to illuminate a particular point in history involving actors at a particular point in time, because I mean, a human universal is a given as a backdrop to what we know about people. So it's not something that is quintessentially a part of any one culture by definition.
But if everybody on both sides of the table both shared a trait of being generous and fairness and equity, if those three traits were among the universals, would that help the judge in any way to understand what people may have been thinking? And I know it's not an exact science, of course, but it's got to be of some help if everybody understood them. Wouldn't you agree with that?
Yes, if there are true universals that one can identify, which can assist, obviously then that's the case. But I think my point was that, it doesn't require an ethno-historical analysis to suggest that a human universal was present or absent in any particular instance. You have to assume, if it is truly a human universal, you have to assume that that's part of the patterns of interaction between people. I mean, trade is a good example, right? It's a human universal. People, when they come in contact with one another, they exchange things, and so you have to assume that that's it. That is something that was in place, but it doesn't really help us any further than that. It doesn't tell us, about what one party thought was a fair trade or what was, or the extent of trade. So what I'm suggesting is that you need more specific information to illuminate specific behavior by actors in a particular point of time. You can't rely entirely on human universals.
That's fair enough, but at least it's of some help. It's something the judge can look at.
Yes, if knowledge of human universals is always helpful in understanding human behavior in general.
That's all I'm trying to understand, if you agree with that.
Absolutely.
All right. So have you read Brown's book on
Yeah.
human universals?
Yes, of course.
And in his book, he doesn't actually list all the human universals in a schedule. He just, in his whole book, which is something like 180 pages or so, he talks about them. You're familiar with that?
Yes, in his book, he talks about the problems with identifying human universals to begin with, and also makes a distinction between assumed universals and actual universals. And rather than listing, as you say, in a schedule, all of the different universals that his research has compiled, he talks about the UP, which is the universal people,
Right.
And devotes a chapter to the universal people, and then describes who the universal people are. They are a composite of all of the human universals that he's identified.
But there are other people, and let's turn to Compendium tab 4. There's a list of Donald Brown's human universals in the appendix to The Voice of the Species. Are you familiar with this listing? You see, because I found it a particularly useful way to look at them without having to go through the 192 pages and control F4 and find it for you and talk about it that way. I wanted to get right down to the nub of it. Have you seen his list before?
I have not seen this list before. This is not how he presented it in his book,
No, it's not.
but I'm assuming that somebody, whoever wrote this, The Voice of the Species, which I'm not familiar with, whoever wrote that, according to the first paragraph in the appendix, consists primarily of surface universals of behavior and overt language noted by ethnographers. It does not list deeper universals of mental structure that are revealed by theory and experiments. It also omits near universals or conditional universals. So these are other universals that Brown had mentioned in his book.
Right.
So
I'm only going to go to a few of them because, and what I'd like to do in order to try and save time is if you tell me that, Mr. Schachter, I just don't think that that's one that Brown actually ascribed to, then we'll have to go to his book and we'll have to clear it up.
no, that's fair enough.
Right? Okay, so what I wanted to do is if you look at, I wanted to go through some of the things that Brown says are and are not human universals. So if you look at compendium page 47,
Yes,
on the left-hand side, you will see that the it's all alphabetical, by the way.
yes,
And one of the first interesting things that I thought was a human universal under the C is cultural variability. So it's a human universal that cultures are variable.
yes,
The right underneath that, it's a human universal that there is culture.
yes. It's one of the defining aspects of the human species.
And you agree that both of those are human universals.
Yes,
Now, Brown also under the D says decision-making is also a human universal.
yes,
Now, to be clear, when Mr. Brown is saying that decision-making is a human universal, he's not saying that Anishinaabe people make their decisions in the same way as Europeans do, is he?
he is not.
He's just saying that it's a human trait to have decision-making among a people.
Exactly.
Okay. And another universal under the Ds is distinguishing right from wrong. You see that?
Yes,
And just because it's a human universal to distinguish right from wrong doesn't mean that people in society always do the right or wrong thing. That's why we have criminals, I suppose.
yes, exactly.
And another on the next, under the Gs, one of the human universals is generosity is admired.
Yes,
Okay, and that might be of some help. And under the Is, we have collective identity.
where do you see that?
Identity, comma, collective.
Yes,
And that is a human universal. Now, on the next column, under the Ls, I need some help with this because I wouldn't have thought this was a human universal, but Brown seems to think so. Language employed to manipulate others is a human universal. That's rather a pejorative thing, isn't it?
yeah, as is the next one, language employed to misinform or mislead.
Right. So
It is.
I mean, someone might argue and it might be me, that might be the European construct of behavior, but do you agree that that's a human universal?
Yes, absolutely. It doesn't
right.
mean that every member of the human species routinely engages in manipulative language or misinforming language, but it is a human universal to the extent that there are individuals in every culture who do.
So it's something that the judge should keep in her mind when making her decision. Yes?
Well, as I said earlier, it helps to know what is human universal or what is universal to humans in general.
Right. Under P, we have promise. So promises is a human universal as well.
Yes,
And that's something we should keep in mind. So promises and manipulating people are sort of, I don't know, they don't quite go hand in hand, but both things to look towards. Under
well,
the,
I'm sorry,
yeah,
you said promise.
yes. Under the P, P-R-O-M-I-S-E, promise. Have you, it's on the bottom.
Yes, I think what Brown, if he has used the term, is referring to is that people have promise. Humans have
Oh, not
promise.
promising to fulfill obligations, but
Yes.
promise. Okay, thank you for that correction.
It's not a verb, you're saying it's a noun?
Yes,
Okay.
Okay, so perhaps we can jump then to 47, 37. Under the M, I forgot to mention that, under the M, is that the use of metaphors under M? Is it common trait?
metaphor. Yes, humans have,
A propensity to use metaphors.
it may not be a propensity, but it certainly exists as a human universal.
Okay, thank you, sir.
What is it that exists?
The
Using metaphors?
Yes, the use of metaphor.
Okay. And again, I don't want to be unfair with you. You have identified reciprocity. And indeed, in his list here, he's got reciprocal exchanges of labor, goods, or services under R. This is at page 48 of the compendium,
Yes,
right? And positive reciprocity. What's positive reciprocity? Can you tell us? Reciprocity, comma, positive.
yeah, so the anthropological literature has a lengthy scholarly tradition of studying reciprocity. And reciprocity, it falls along a spectrum. At the extreme end of reciprocity is what's called negative reciprocity. And that's basically,
He's got it here as revenge and retaliation.
yes, it also includes things like theft, which really is at the absolute limit of reciprocity because there's no expectation of a reciprocal exchange for something. And at the other end of the spectrum, at the extreme end of the positive reciprocity, you have what's generally referred to as the gift. A gift is also not true reciprocity, but it is because there's not necessarily an expectation of something in return. But in between those two extremes, you have a wide range of reciprocities that vary considerably, from an economic exchange to a more symbolic exchange to. So that's why there's both a negative and a positive end to reciprocity.
Okay. And the last one I wanted to refer to is on the, still on page 48, under addition since 1989, on the first column, under F, fairness, equity, concept of. So that's a human universal as well.
Yes, concepts of fairness, I would agree, are found in every culture.
Now, we've talked about what are listed among Brown's universals. And you have said in your work, in your report, that happiness is a human universal, but you won't find happiness on Mr. Brown's list of universals. And you won't find anything then other than a smile indicating happiness in his book. Happiness, or Minabemazwin, is not a human universal. Would you agree with that? Maybe we
Well-
should separate them. Happiness is not a human universal, according to Brown.
He may not use the term, but there's no question in my mind that you have to reverse the question and ask yourself, what humans do not strive for happiness? I mean, if you can think of any human culture that does not strive for happiness, then you have found the exception to the universal.
But all I can tell you is that Mr. Brown doesn't identify it as a human universal.
Is your question, he doesn't identify the pursuit of happiness or the goal of happiness or?
Yeah, I think we should refine it.
Okay.
The pursuit of happiness or the goal of happiness is not identified as a universal by Brown. Would you agree with that?
Well, it's not listed under happiness, under H, happiness.
Do you want to go through, and we can control F4 his whole book for you and search for the term happiness, if you like, and it'll show up as under the only time happiness shows up in his book is in respect of facial expression of happiness. And that's not the pursuit of happiness. Would you agree?
Well, happiness is, I would assume, an epiphenomenon of some other state. An epiphenomenon of one of those human universals. So it may not be specified, but again, return to the question, you know, what I ask myself when I think of the human universals, I look for the exceptions, and I mean, I've been an anthropologist for, you know, nearly half a century, and I cannot think of any culture that strives for unhappiness. So
Sorry,
it's-
I'm using happiness in the context in which the judge has indicated, which is the pursuit of happiness as a goal. And, you know, the Americans in their constitution talk about the pursuit of life, liberty, and, you know, I think, and can't even remember what it says right now. But there are certain pursuits, and we're talking about the pursuit of happiness. And I suppose perhaps the reason why it's not on the list might be that there are some cultures that don't pursue happiness in the way Minabemazwin has been characterized, but pursue survival. Would you agree with that?
In my view, the pursuit of happiness is not a cultural trait. It is a human trait.
Would you agree with me, sir, that Minabemazwin is not, as defined by the witnesses in this case and by Dr. Dribbin, is not a Brown human universal?
Well, the expression of the pursuit of happiness will have cultural variability, but the underlying goal of being happy, I think, is a human universal.
Would you agree with me that Mr. Brown in his book of Human Universals does not reference the term Minabemazwin?
Of course not.
You don't agree with me, or you do agree with
No,
me?
he does not.
All right. Would you agree with me that in his book, Mr. Brown does not identify the pursuit of happiness as a human universal? And we can go through the book and we can go page by page if you want.
He does not list happiness as a human universal.
Thank you.
Could you just see, the question was specific. The question was, in the book, Brown does not identify the pursuit of happiness as a human universal. And your answer was, it doesn't list happiness. Are you disagreeing with Mr. Schachter, or are you agreeing that he does not list the pursuit of happiness as a human universal?
He does not list the pursuit of happiness as a human universal.
Okay,
Thank you. Can we go to your slide deck? We can leave this now, and thank you for helping us with that. Can we go to slide deck 15, please? In the perspectives report. Now, we've been to this slide, I think, before, but in rejecting Dr. Dribbin's opinion about the Anishinaabe expecting a generous share that would not overwhelm the Crown, in addition to, we talked about the ethnohistoric evidence, we talked about your concerns about methodology, but you identify two problems in the middle of the page. First one is it does not assist in quantifying compensation. And then the second one is inconsistent with the RST plaintiff's suggestion that a fair share would be 100% of net Crown revenues. You see that there?
Yes.
Now, when you say does not assist in quantifying compensation, do you mean to say that such a statement by Dr. Dribbin does not help the judge know exactly what the dollar amount is? Like, it doesn't help the judge understand the exact dollar amount? What is that what the complaint is about quantifying compensation?
Well, not only does it not help an exact dollar amount, but without defining what generosity over or a definition of overwhelm are, I don't see how it can help in any way. I mean, if the phrase "a share that would be generous but not overwhelm the Crown" helps, fine, but I don't see how it can reach a level of specificity that is of any help, because
Okay.
and I'm not. I mean, it's quite obvious that it can't help to define a particular quantum, but I don't even know if you can use it to in a more general sense either.
Well, but certainly let me put it to you this way. If the Anishinaabe said what we think is a share that is appropriate is everything that the Crown gets, that tells the judge, if that was the case, if it was the case, that would tell a trier of fact, the judge, something about the mindset of the individual who held that belief, right?
Yes.
Similarly, if you have evidence that they wouldn't take everything, that tells you something about their mindset as well. It doesn't tell you a percentage, it doesn't tell you an exact number, but it tells you something about the person who was there in 1850, right?
Yes.
Thank you. Your second complaint was that it's inconsistent with the plaintiff's suggestion that a fair share would be 100% of net crown revenues. Now, you attribute, basically what, as I understand your position, sir, because Harley Schachter, counsel for the RST, stood up in court and said that perhaps a fair share, when fair share was important, was 100% of the net crown revenues, that somehow Harley Schachter, the lawyer, is the arbiter of Anishinaabe cultural perspectives. Is that what you were trying to convey?
No, I perhaps I'm wrong, but I can only assume that you represent the RST plaintiffs. And in that capacity, serve as their voice in this court.
All right, and so let's go with that. Let's suppose that that is true for a moment. Is it fair that your complaint assumes that 100% of the net crown resource revenues is 100% of the benefits the crown gets from their resources?
The 100% of net crown revenues that I'm referring to would be the shareable excess, the total amount of the shareable excess.
Yes, but you've assumed that in asking for 100% of the net crown revenues, which was what the lawyer did on the record in phase one, is asking for 100% of what the crown got. That's a false assumption.
Well, if it is, then then I apologize. But
Thank you.
I don't know how else it can be read if it's 100% of net crown revenues.
What if I told you that the financial benefits the crown actually gets from the resources is not only net crown resource revenues, but also includes other significant financial benefits, such as taxes, such as benefits for other members of society, other people? Would that perhaps give you some context about the Anishinaabe not asking for 100% of everything?
So let me get this straight. What you're saying is what you meant by 100% of net crown revenues was only the revenues that the crown received from the lands. And there are additional revenues that are not proceeds from the lands, which you don't include in that.
No, I'm suggesting to you, sir, that the evidence before this court already is that the benefits that the crown gets from the revenues is made up of net crown resource revenues, plus other things as well. And those other things, and I'll just give you an actual number example. It's we've had some experts, our experts, the plaintiff's expert, have calculated that over the years up to 2019, the nominal amount is about $1.58 billion, right? And on top of that, the crown received somewhere between that and I think 3.5 billion or so in benefits. So somewhere between there, the crown got other benefits. So the total amount, the evidence already suggests that the crown gets is more than the net crown resource revenues.
Your Honor, if I may,
Mhm.
I would ask that my friend advise this witness that the role, if any, of value to the crown beyond net crown revenues is very much contested in this case. So the wrong impression is not left as his questions are asked.
Put it as a hypothetical. Or just,
I mean, I'll put it, maybe I can put it this way. If, as a hypothetical, you can do a hypothetical. If in fact, this is my hypothetical, that the full benefits the Crown receives is not net Crown resource revenues, but it's something more, then your complaint doesn't hold water. We should reject it. It's not fair. Because we're not asking for 100%. It's just a hypothetical.
Well, that particular nuance that you've introduced to this was not I was not left with the impression that those additional amounts beyond the shareable excess was being asked for. Perhaps I'm wrong about that, but I was assuming that the 100% of net Crown revenues was 100% of the shareable excess as I calculated it in my own hypothetical that I gave in my report, because I can't point to an example since nobody's ever, since nothing in the historical record provides for such an example.
Dr. Von Gerner, you've kind of skirted around the question. Would you agree with me that on my hypothetical, your complaint that about the ask being inconsistent with Anishinaabe wanting to not overwhelm the Crown by asking for 100% of net Crown revenues from the resources, which is what you meant, is not a fair criticism? Under my hypothetical, I grant it.
Yes, then it would not be a true 100% request. It would be only 100% of a subgroup of what is now a much expanded shareable excess.
Thank you, sir.
Could I ask this, and I really hope it doesn't throw it off. Do I understand when you make your criticism that you are basing it on an assumption that 100% of net Crown resource revenues and CRRs is all of the revenue that there is, that is generated and that goes to the Crown? Are you basing your complaint on that assumption?
Yes, you're correct, and that was my assumption.
You don't have to justify it. I just want to know if that is the correct relationship.
That is the correct relationship.
Okay.
Yes,
But
thank you.
the assumption, I mean, I need to clarify that because my assumption was based entirely on the Court of Appeal wording. And what I understand from the trial record was that this court did not accept that was actually, that 100% was actually that 100% could be a share to begin with, because by definition, 100% is not a share.
All right, thank you, sir. I think we can move on. It's fair, Dr. Von Gerner, that you proceed with your analysis on the basis that, on the interpretation, excuse me, that the Crown actors believe that there was a cap on the collective entitlements, right?
I'm sorry, can you repeat that?
Your reports proceed on the basis of your interpretation of the history that the Crown actors believed that there was a cap on the collective entitlement. Is that fair?
Yes, the general understanding that underlies Crown actions here in the half century after the Robinson treaties were signed was that the maximum amount was a figure that if you divide it into a per capita basis would result in a maximum of $4. There were, as I gave the example of Dawson in 1873, there were some who mused about the possibility of it being higher, but for the most part, the actions of the Crown can only be explained if that assumption was in fact one adopted.
I wasn't asking you to defend your thesis or defend your position or defend your conclusions. Just asking, I just wanted to make sure, understand that was the basis of your reports. It was fundamental to how you looked at the Crown conduct. What you didn't do, sir, is you didn't seek to consider in your reports their conduct or actions on the basis of there being either a $4 soft cap on the amounts paid to individuals, or that there was no cap on the collective entitlement. You understand what I'm asking? You want me, or do you need me to
Well,
rephrase it?
my reasoning is actually the reverse. I first looked at the Crown actions and then tried to understand why those actions took place. And the reason behind those actions turns out to be this understanding of the augmentation clause.
Right, but the scientific method, one of the ways you can do is you can put forward a hypothesis and then you test that hypothesis, right? And one of the things that you could have done that you didn't do, and I'm not, I don't want to worry about whether you should have or not. I'm just trying to establish you didn't do it. What you didn't do is you didn't say, how do we judge the Crown's conduct if it's true that in fact there was no cap at all? You don't do that exercise.
Well, sir, I'm not in the business of judging the Crown conduct. I only try to explain the Crown conduct.
Well, okay. You didn't try and explain the Crown conduct under the assumption that there's no cap. Right? You in your analysis, I don't see anywhere in there, and maybe you can correct me if I'm wrong. I don't see anywhere where you say, if it was true that there was no cap at all, this is how I explain their conduct. You don't do that.
Well, if it is true that there is no hard cap, then the entire history would be inexplicable.
That's what that's what you're saying on the stand here, but you didn't actually turn your mind to looking at each letter, each document with that mindset that there was no cap. You didn't do that.
Well, I was obviously aware of the Court of Appeal decision in that respect. And so it was always in the back of my mind. It's not as if I entered this project blindly.
Would you agree with me, sir, that if you called it, their conduct would be inexplicable? But I want to break that down just a bit more. If you were to assume, and now we're in the hypothetical, it would be easier for us if we stick with the hypothetical with you on this series of questions. Let's use it as a hypothetical that there was no cap on the collective annuity entitlement. Now, in examining the Crown's conduct, there's a couple of options that I see logically, and I hope you do too. So the first is that the Crown actors could have known and believed that there was no cap, but pretended that there was a cap. Now that would be consistent with the human universal of using language to manipulate, misinform, and mislead the Anishinaabe, right? That's one possibility. I'm not asking you to adopt it, but do you agree that that's one possibility?
That is a possibility. That's in the short term with certain actors, but it's unsustainable in the long term, over 50 years with so many minds, so many humans involved in this story.
All right, so let's talk about some of the things that, if in fact it's true, and this is just a hypothetical in our discussion here today, that there was no cap on the collective annuity entitlement. The Crown actors could have done a number of things to understand the true meaning of the treaty. Remember, there's no cap, but some of them seem to think that there is a cap, right? But there's a couple things they could have done to clear things up. They could have reached out to the Anishinaabe to meet with them, right?
Yes,
That didn't happen, did it?
yes, not on any high formal level.
They could have consulted with the witnesses who were present at the treaty talks.
I think ideally that should have happened, yes.
Didn't happen though.
No, it didn't.
They could have responded to numerous petitions sent to the Crown whereby the Anishinaabe claimed they were entitled to more than $4. I don't see any response to those petitions.
I'm not sure which ones you're alluding to, but there was the occasional claim that there was that they were supposed to receive $10 or that they were supposed to receive something beyond $4. But in those instances, yes, I do not see any response to those petitions. They did not respond to them.
They could have responded to Dawson's 1873 request for such further sum as Her Majesty may be graciously pleased to order over and above $4. They didn't do that.
Well, that was Dawson's view.
Well, no, I
Right.
appreciate it's his view, but I
Yes.
don't see a response to it. I see a response to a request up to $4, but I don't
Yes.
see a response to over $4.
No, because the understanding was that it wasn't over $4.
Well,
So-
later on today, I'm going to go through some documents and I'm going to try and convince you that you're mistaken about that, but we'll have to wait for that. And
Sorry, I just want to get this.
Yeah.
Mr. Schachter's asking questions about what Crown actors did. And your answer was, no, because it was the understanding that.
Yes.
But you're being asked to answer the questions on the basis of a different assumption.
Yes, if we're assuming the hypothetical, the Crown did not act on that.
and they didn't act on it, in fact, no matter what they thought. Right? Even assuming your hypothetical, your belief and understanding that they believed that there was a cap, they didn't act on the requests that were made.
Well, they did in 1875.
Sorry,
they
the
augmented-
request, we're talking about the request for more than $4.
No, there was no action on that.
Another thing that the Crown could have done is they could have followed up on such further some language in the treaty. They did, I don't see that they've done that.
You mean the graciousness clause?
Let's call it that.
that was, that came up from time to time, but they did not ultimately act on it.
Thank you. And I guess the last thing that I think they might have wanted to do is review the speeches of the chiefs before they went missing in 1858. That's something they could have done as well.
Yeah, I always wondered about that. Robinson had those speeches until 1857, at which time he provided copies of them to Pennefather. And we have no idea what happened to them after that.
The question was,
The question was simply that they could have consulted the speeches before they went missing.
Well,
That may have been helpful.
I don't know. Robinson said he dug them out of, his house somewhere, and then, so I don't know how accessible they actually were. They were in Robinson's personal possession and handed over to the Crown in, I believe, in 1857. And after that, we lose track of them.
Yeah. But my point is that what the chiefs had to say in the speeches, Robinson said it would be of use in case there was any dispute about what happened at the treaty talks, right?
Exactly. Yeah.
And so it stands to reason that one of the things that the Crown could have done is looked at those speeches, but they didn't, as far as you know.
Yeah, as far as I know, the Crown received the speeches in 1857, and I have found no record of any review of those speeches. I literally do not know what happened to them. I don't think any of the experts uncovered any reference to them.
All right. Now, those failures that we talked about, if one were to assume that, again, there is no cap, and if the Crown actors were deceitful and they knew there was a cap, but they didn't, they didn't want to say so. That's like, can I call it bad conduct, morally reprehensible conduct? That those failures are consistent with active misleading, but they're also consistent with other things as well, right? It's consistent with them being bad people, but it's also consistent with them perhaps being negligent, or it's consistent with them being, have you ever heard of the term willfully blind?
Yes.
So it's consistent with them being willfully blind as well.
If they understood the augmentation clause to be different from what they assumed it to be when they augmented it to a maximum of $4, then yes, that would be, in my view, that would be a misconduct. I mean, if they knew that the intentions of the parties in 1850 were to have this augmentation to be unlimited,
Yes.
as opposed to having some kind of cap, and yet they proceeded as if it had a cap, then I think that would be wrongful conduct.
But it's also possible that, and this is being perhaps more charitable to the Crown actors, one could say that the failure to make inquiries or consult the Anishinaabe is not consciously deceitful, because maybe they had the honest belief that there was a cap, but it would also be consistent with Crown actors not wanting to know what the truth was, which is something called willful blindness. You've heard of that before.
Well, I'm familiar with the term willful blindness.
Do you think that, based on what you know about the facts, willful blindness is a more likely explanation for the Crown's conduct under my hypothetical than deceitful and wrongful conduct? Is that fair?
You know,
These are loaded legal terms. I wonder if they're crossing it out here.
Well,
he told me-
I
he
don't
said
think
he knew.
that there, I don't think you have to presume that there is anything riding on the exact legal definition of that term. Is that fair?
Yeah.
And
that's fair
I
for
want to
me.
say that to the witness as well. Use
Yeah.
willful blindness as it's understood colloquially.
yeah, that's helpful.
Okay.
They know enough to turn their mind to willful blindness. They know enough to turn their mind to that perhaps there may be a problem, but they choose not to figure out what the truth is. And I'm suggesting to you, I'm asking you actually, because I want to know your opinion, I really do. Do you think it's more likely that if you assume that there is no cap, that their conduct is explainable by them being deceitful or them perhaps being willfully blind, as you understand the term? Well, okay, or is there another explanation? Could they be negligent?
Uh,
I mean, what?
I have seen a great deal of Crown conduct that over the years that I regard as willfully blind and that's negligent and that shows no honor on the part of the Crown. So I know that it's possible. I'm not suggesting that it's not possible, but I always tried to get into the minds of these people in the 19th century and not impose our modern understanding on them.
Yes.
And so in your hypothetical, if you put it that way, of course, on its face, that seems that, you know, there's something wrong there, right? I mean, that's not the way any party should conduct themselves. However, there are also other considerations because there are the Crown, even if it understood that the $4 could be augmented higher, still had other considerations to consider, including the maximum given in other treaties during the 1870s. And so, you know, I'm not trying to be obtuse here, but there's also the difference between whether you're in your hypothetical, you mean an augmentation to another cap higher than 4, or whether it's an augmentation in an unlimited amount. And the conduct would be quite different in either of
I
those
mean,
scenarios.
an augmentation to an unlimited amount.
Yes, well, if they understood that it was to an unlimited amount, then I think it'd be fair to say that it would be a misconduct if they understood one thing and acted quite differently.
But just to be clear, and I don't want to be unfair to you, I'm asking you, based on your reading of the historical record and what you know as a historian, anthropologist, ethnohistorian, how, based on the record you know,
Yes,
if it's true that everybody in 1850 believed there was no cap on the collective annuity, how would you explain the conduct of the Crown actors in what they actually did do?
Explain or describe.
Describe or explain. Is it bad faith? Is it willful blindness? Is it negligence? Is it something else?
Yes, if everyone understood, if all Crown actors understood that there was an unlimited,
In 1850, I'm not saying in 1873, in 1850. Right?
If
It's the
Cro- if
Crown
all-
actors in 1850 understood that there was no cap on the annuity at all. You've looked at the historical record about what people did and didn't do. And I'm asking, how would you assess the bona fides of their conduct?
okay, that's a slightly different question because I thought you meant all Crown actors throughout the period from 1850 onwards.
Well, that
They-
is
they-
one hypothetical, but I'm asking you, because there's a couple of scenarios, possibilities. One is they actually knew and they were lying,
Right,
and that's really bad.
yes.
Do you think that that's a possibility?
Well, I'm somewhat confused here because when you say all the Crown actors in 1850, the Crown actors in 1850 are not the ones who are acting after 1850 to administer these treaties.
Yes. Not,
So if you're asking if the Crown actors in 1850 understood that there was no cap, that it was an open-ended deal, I don't know what subsequent action I am supposed to be comparing that to, other than the actions of other Crown actors who weren't there in 1850, because they're the ones administering the treaty, right? So the Crown actors that I refer to throughout most of my reports are those who are administering the treaty after the treaty was signed.
right, but we went through a list of things that they could have done to discover the truth. And they didn't do those things, right? And what I am trying to understand is, if you assume that there was no cap, how do you explain their conduct and what they did in implementing it? And I'm talking about the people who weren't there. Do you explain it on the basis of, does the record suggest to you that they were bad people with evil intent who knew they were lying? Does it suggest that they were just didn't care and turned a blind eye to it? Willful blindness, or perhaps that they were negligent, or perhaps something else? And I'm just trying to get your sense of how you explain, in light of the historic record.
Yes, if the Crown actors who were responsible for administrating and paying the annuities under the Robinson treaties were of the understanding that at the time of treaty, there was an agreement that there would be no cap, and yet they acted as if there was a cap, then I think that would be a misconduct of some sort, no matter how we define it.
And suppose that those same individuals didn't know what the bargain was in 1850. Do you find evidence that in the record that there were indications from the Anishinaabe that that might have been the bargain?
Most of the petitions that were acted on and that I describe in my report led the Crown to believe that they were asking for the maximum of $4. And that was in accord with their own understanding that there was a cap of $4. There are some indications, as you say, in the record of Anishinaabe understanding that they would, that they were entitled to more.
And the
But
fact that
those were-
that wasn't followed up on, doesn't that? You want to finish? What else was there?
I was just going to say that was not followed up on.
Okay.
What was not followed up on?
Any indications that the Anishinaabe or the individuals who were assisting them, any hints that they gave that there might be more that they were entitled to?
It wasn't followed up on, right?
Yes.
Doesn't that tell you something about their conduct and about how we should assess their conduct? They knew there were complaints but didn't follow it up. Doesn't that suggest that they're turning a blind eye to the complaints?
Their interpretation of the augmentation clause was such that they acted on their understanding of the clause rather than on any claims that were made by the Anishinaabe or their supporters, with the exception, of course, of those petitions which resulted in the augmentation to $4.
All right, perhaps we can, go ahead.
Could I just get that answer again? I'm not seeing a transcript for some reason. Oh, here we go. The question was, does it? Well, the first question was, they didn't follow up, right, on any, as you call them, hints or indications that there was more than $4. So they didn't follow up. And then the next question was, does that tell you something about their conduct? That there were complaints, but not followed up on? And your answer is, well, their interpretation doesn't seem to me to be responsive to the answer. Their interpretation of the augmentation clause was such that they acted on their interpretation rather than on any claims that were made by the Anishinaabe or their supporters. So I thought when I listened to it, I'm now looking at it, I thought when I listened to it, it was sort of circular. Their interpretation was such that of the clause was such that they acted on their understanding. But the question was about, in the face of what you call hints of a claim that the augmentation could be more than $4, they didn't do anything. So the question elicited an answer that they did not do anything. They ignored it. But your answer is their interpretation was such that they acted on their interpretation.
Yeah, the Crown actors acted on Anishinaabe petitions that suggested that there was a $4 cap. There were other petitions from time to time, very few that I recall, that were not acted on in the sense that there were no additional augmentations made beyond $4. Right. So
I
there's-
suppose my problem is, and I think we had this before, it's, mistakes were made. is an answer that people give when they don't want to say, this actor made a mistake, or this actor did not follow up on, or this actor ignored those, or this actor never mentioned those, as opposed to they were not. So I'm just trying to, the answer was, or the questions to me, as I understood them, were quite specific about Crown actions.
Yes.
And I have been getting the impression that you don't want to say something about Crown actions.
Well, no, I've said, I gave over 300-page, 400-page report on Crown actions. I have no problem talking about Crown actions and inactions. I gave an entire, section of a chapter to Crown inactions. So I'm not reticent to say that at all. But I think what Mr. Schachter was alluding to was that there are a few hints in the record of Anishinaabe claims that were above $4. For example, there was one late in the 19th century. And,
We're not talking about the Anishinaabe petitions.
but Mr. Schachter was
So he
asking-
put to you those petitions and asked you about the Crown's response to them.
yes. And what I'm saying is that the Crown responded to some, but not others.
Where
would-
there were hints of more than $4.
They didn't respond to those.
No,
And that tells you something about the Crown's mental state, does it not? They were turning a blind eye to the requests for more than $4. That's all I'm trying to establish.
I don't think they were. I don't think they were turning a blind eye. What they were doing was, in their view, it was a mistaken view, and that's not turning a blind eye. It's just making an assessment of, because these claims, many of these Anishinaabe petitions are mutually exclusive, and so, because they're inconsistent. I mean, in one, they're claiming that, after 4 years, they should be getting $4 per capita. And then in another petition, they're saying, well, they should be getting $4 after 1 year. And then something else beyond that, after that. And then in another petition, they're saying, well, what they're asking for, or what they think the deal was, is that they should be getting $10 and they're only getting $4. So, the Crown is not necessarily turning a blind eye to these things. They have to make a decision as to what the actual deal was. And in making that decision, they assume that it had a $4 cap,
Right.
if that makes sense. I mean, it's not, I'm not trying to suggest that the Crown's not turning a blind eye. In your hypothetical, if they are in fact thinking that there is no cap at all, which the Anishinaabe petitions aren't really saying, but if there's no cap whatsoever, and they're still persisting with the $4 cap, then absolutely they're turning a blind eye, and they are, willfully disregarding.
And they're bad actors.
They're bad actors, absolutely.
All right, let's just change the line a little bit. Suppose that the Crown actors in 1873 had the honest belief that they weren't sure whether there was, this is hypothetical,
Yes,
they weren't sure whether there was an entitlement to more than $4. Changing the hypothetical.
yes.
Given that they didn't follow up on the request for more than $4, how would you assess their conduct under that hypothetical?
So they're not sure.
Someone, perhaps Dawson, has said they're entitled perhaps to more than $4.
Yes. Or Van Kugnet or whoever. Yeah. So,
So if their mindset was that they had the honest belief that maybe they're entitled to more. We know they didn't follow up on it.
yes,
What do you say about, under that scenario, under that hypothetical, can we say that their conduct was being willfully blind to the possibility that there was in fact more due than $4?
if they believed that they were unsure, or if there was a question about
Yes.
the possibility, and they persisted with the $4. I suppose in some sense, under that scenario, they should have provided reasons for the course of action that they did take, as opposed to simply assuming,
Yes.
right?
So it would have been wrong to assume.
Yeah, under such a scenario, they mean,
But under the record that exists in the historic record that you've examined, is their conduct bad conduct? Is it turning a blind eye? Is it willful blindness? What is it? Or is it something else? What is it?
Sorry, under which assumption are we?
We are under the assumption whereby the people in 1873, 1874, and 1875 who are administering it have the honest belief that the entitlement may be more than $4 per capita.
if you have an honest belief that it might be more than $4, and they didn't,
Well, we know what they did. It's in the record.
yes,
Yeah. How would you assess their conduct?
well, under that circumstance, I think they needed, at the very least, to then justify the decisions that were made, because you can't leave it as a matter of uncertainty. You have to come to a decision as to what your interpretation of this treaty is. But if there's any uncertainty, then that should have been justified in terms of the decision that was ultimately made. You can't leave it up in the air. There has to be some kind of justification for the decision that you make. That they were never, you know, I don't know if I define it as, you know, a bad actor. If they honestly believe that there's uncertainty about it, to me, there's an inaction,
Right.
not so much a bad action. There's an inaction in the sense that you don't go back and review and justify the interpretation that you end up having, which is the basis for your administration of the treaty.
But inaction can have grievous results, and we're going to break shortly. I just want to finish this area, if that's okay. Inaction can result in pretty grievous results,
Yes,
right? And so would you agree with me that the inaction, based on the facts of history as you know them, under this hypothetical that we've just talked about, suggests that the Crown was turning a blind eye to the rights of the Anishinaabe to more than $4 as claimed by them under the hypothetical.
Yeah, I think that kind of inaction would not be fair to the Anishinaabe. But more importantly, I think what should have happened is a better justification for the actions that did take place, as opposed to turning the question around and asking, well, if they were uncertain about it, you know, and they still persisted, is that a bad action? Right. I mean, at the end of the day, they had an assumption. And I'm not suggesting that this assumption was universally, absolutely universally an assumption understood by everyone. But it was the main one that drove the actions that resulted in the $4 cap. And that, for some, may have had some uncertainties. And the very fact that those uncertainties existed should have occasioned at least a justification for the actions that were taken based on the assumptions they did have.
Okay, I think perhaps we've reached a point where we should break.
Thank you. I'll just catch up for a moment, please. Okay, we'll take a break.
15 minutes.
This court will recess for 15 minutes. This court will now resume, you may be seated.
Please go ahead. Okay. No problem.
We ready? No? Okay, we'll just wait then. Okay. Dr. Von Grunert, we're going to move and talk about your just demands report. And I wonder if you could turn up slide 98. Under chapter 6, unfinished business. At slide 98, which tracks in respect of the question I'm going to ask you, it's at also at page 304. You opined that Treaty Commissioner Robinson envisioned an annuity fund.
Can I just get, I just want to make sure.
Yeah, slide 98.
52? No.
It's exhibit 52, slide 98, chapter 6, unfinished business. And you'll find the same verbiage at page 304 of the report itself, where Dr. Von Grunert opines that Treaty Commissioner Robinson was envisaged an annuity fund. That's I want to ask questions about that. Are you with me?
Yes, I am.
All right. So you will agree with me, sir, that Treaty Commissioner Robinson never said in his writings, in his report, that he envisaged an annuity fund.
He never used those words.
All right, that's all I asked.
Yes,
Now I asked, he never used those words.
yes.
What he did say was that the treaty he concluded avoided having to account to them for future sales, a course that would have entailed much trouble for the government. And I'm paraphrasing, but I think that's probably fair. I think it's paraphrasing from your slide 98.
Yes,
What Robinson was referring to, sir, was avoiding the problem of accounting to them as if they were surrendering their reserve lands parcel by parcel. Would you agree with that?
no,
Would you agree that Robinson was trying to establish that he was not trying to set up a land fund? Would you agree with that?
Robinson was not following the land fund model. He had an annuity fund model in mind, not only because of what he says in the words we just used from my report, but also because he had received instructions to assume a capitalized account that would lead to a fixed annuity.
But they didn't settle on a fixed annuity, sewer, and what we're talking about, unless I'm mistaken, are you suggesting that he understood the annuity fund in respect of a fixed amount, not in respect of an augmentation? Because maybe we're just talking at cross purposes. Maybe I misunderstood.
No, he understood that there was a fixed amount payable under the annuity,
Yes.
but that it could not but that it required a condition in the augmentation clause to meet the full per capita payments under that fixed annuity.
But excuse me, there's nothing that Robinson said in 1850 that would lead anyone to believe that in respect of the amounts over pound 500,
Yes,
which is what do you want to call that?
the pre-augmented.
The
annuity.
pre-augmented annuity. And anything greater than that, whether there's a $4 cap or not, it doesn't matter. there's nothing in what he said to suggest that the amount's greater than £500 per annum would be put into an annuity fund. Would you agree with that?
No, he was asked, after he asked how much money is available, he was given an answer. And the answer is, this is how much there's available. However, you should assume, or you should negotiate on the assumption that there will be I think it was $100,000 capitalization. And from that, he'd have to deduct the down payment and then calculate whatever remained as the annuity that was payable.
Yeah, I think we're talking at cross purposes. Mr. Robinson was not given instructions to negotiate an augmentation clause, was he?
That's correct.
To the extent that he was given instructions for a fixed amount that could be capitalized, you're saying he understood it to be an annuity fund, correct?
That's the only way that it can be understood, and that he presumably did understand, because at the time you had either annuity funds or you had land funds. And it's the annuity fund that he's envisioning here. He's not envisioning a land fund.
Well, okay, he's not envisioning a land fund. And I'm with you, and I understand that the fixed amount, the £500,
Yes,
he understood would be part of an annuity fund. It could be part of an annuity fund because it's fixed. You can capitalize it, right?
yes,
And he had instructions for that. And you make the point that he had instructions to treat it as a capital amount, right? But the annuity agreement augmentation clause actually says that the annuity of £500 shall be augmented from time to time, right? That's a
Yes.
fair paraphrase.
yes.
From time to time is not a one-time capitalized annuity fund, is it?
That's correct. It would require additional, I mean, I made this clear in my report. It would require an additional amount, irrespective of whether it was capitalized or not.
That's right. So it doesn't have to be in an annuity fund, or sorry, clear on the record. The augmented annuity did not have to be an annuity fund. It could have just been a payment.
Well, it would, whatever it was, it would have to be added to the annuity funds.
No, it wouldn't have to be added to the annuity fund. It could have just been paid out to the Anishinaabe in the year in which it was earned. Let's use a hypothetical. Suppose in 1856, there was $39,000 extra. $39,000 could have been paid out. Wouldn't have to necessarily be paid out of the annuity fund. Could have, but it wouldn't necessarily have to go in there. It could go in and immediately out. Or it could just be paid through the consolidated revenue fund directly without going to the annuity fund, right?
Or it could be not paid out at all and allowed to accumulate until it was sufficient for a capitalization to allow the maximum payment.
Well, it could have, but Robinson didn't say that that's the way it should function.
No, he did not.
Thank you. Now, in your report at page 10, and this is your just demands report. You have a section about how surrenders and treaties were made, and I'm going to try and summarize to save some time. As I understand it, your position is, and what you've told the court in your report, is that there were large surrenders for annuity monies. Another model was a proceeds model for surrenders of portions of reserves. That's basically what you're telling the court are the two options.
Yes, the large surrenders or that involved the extinguishment of Indian title to large tracts of land involved originally lump sum payments and after 1818 annuity payments, whereas surrenders of reserve lands or small tracts involved a proceeds model in which the lands were sold for the benefit of the First Nations that had sold the land.
Would you agree with me, sir, that reserves set up after there has been a treaty for surrender are unsurrendered lands in the Robinson Superior Treaty area?
I'm sorry, say that again.
Reserves established under the Robinson Superior Treaty
Yes,
are not, sorry, reserves established under the Robinson Superior Treaty are simply unsurrendered lands. Would you agree with that?
I think that's more a legal question, and I understand there has been legal disputes about what the actual status of reserve lands was. The Crown tended during the 19th century to understand lands set aside as reserves as being Crown lands,
Yeah.
which were for the exclusive use and occupancy of the indigenous peoples
Right.
for whom it was reserved.
And in factually, that happened in Treaty 1 and Treaty 2 and Treaty 3, where the whole of the land was surrendered and a reserve was granted back. But that's not what factually happened in the Robinson Superior Treaty territory.
Again, I don't know what you mean by factually happened. I can only tell you how the Crown understood these. Because what factually happened is, to me, uncomfortably close to what is a legal
All right, I'll deal
pronouncement.
with it in a hypothetical then. Let's take as a hypothetical that under the Robinson Superior Treaty, where there was a surrender of reserve land, those reserve lands were unsurrendered land prior to them being surrendered. Okay, that's
So-
just a hypothetical. I'm asking you to agree with a legal position that you don't feel comfortable agreeing to. I'm just putting it as a hypothetical. I'm going to suggest to you that there are proceeds models for the surrender of large tracts of land over and above just for annuities. That there's proceeds models, not just for surrenders of small portions of reserves, but for large portions of reserves as well. Would you agree with that?
The Crown generally used the proceeds model for anything it considered to be reserve lands.
So
no
in
matter
treaty,
what the size.
yes. So Treaty 9 and 10, which you'll find at the compendium compendium tab 5 involved 352,707 acres surrendered on January 15, 1798 and February 6, 1798. And you would agree with me that that's 352,707 acres is a lot of land.
Yes, you're now introducing something totally different. This is not even comparable.
I
First of
haven't
all,
asked the question.
yes, yes, it's a
My
lot.
question is it's a lot of land?
It's a lot of land, yes.
And my second question is it a proceeds model? Yes,
It's a proceeds model,
thank you.
but it's not understood as a reserve.
Okay, so it's not understood it's a reserve. Okay, that's fine.
So, first of all, when you say treaty number 9, let's distinguish these. These are not the numbered treaties.
Yes, okay, fair enough.
This is not the treaty number 9 of 1905, right? This is the original numbering system for pre-Confederation Upper Canada instruments. This is like I said,
This is the number in the Canadian Indian Treaties and Surrenders, Volume 1, of which is Exhibit 12 in this column.
yes, and it's not to be confused with the treaty number 9 that I talked about. This was a tract that this requires context. You can't just simply compare this with any other with a reserve session that leads to proceeds. These are lands that the Haudenosaunee did not have any form of traditional association with. These were lands for which the entire Indian title had been extinguished back in 1784. After the American Revolution, which ended in 1783, the Haudenosaunee were part of the Loyalists who came north and wanted lands, and just like other Loyalists who ended up in what is now Canada. And the government at the time engaged in a treaty-making process with the Anishinaabe known as the Mississauga. So these are Mississauga lands. And the Mississauga relinquished those lands for a lump sum payment. There were no annuities back in 1784. So these lands were originally Mississauga lands. The Indian title was extinguished in 1784. The Haldimand then issued a proclamation giving us a small portion of those lands, that is the Grand River Valley, to the Haudenosaunee, or Six Nations. And subsequently in 1793, Simcoe granted them a patent for these lands. That whole scenario is entirely unique in Upper Canadian history.
So
It's not that-
each transaction, each treaty has to be dealt with uniquely? Is that what you're trying to tell me?
No, what I'm saying is that the example you're choosing is the most anomalous in the entire history of treaty making in Canada, because this land had the original Indian title had already been extinguished in 1784 by purchasing it from the Mississauga.
What difference does it make to my question about the size? I'm asking about whether you can have large tracts of land for sale, large tracts surrendered, whether it's reserve or not, they're surrendered not for annuities, but for proceeds. That's all the point I'm trying to make.
Yeah, if that's your only point, Yes, I mean, it's
Thank
still,
you.
it's still a very small tract compared to the Robinson treaties or the number treaties.
All right. And you also made the comment that, well, annuities weren't in place yet. And is that perhaps one of the reasons why they had to stick with proceeds? Because annuities weren't in place? Or is that not a factor?
No, I don't think that's, no, it's not because annuities have not been in place yet.
Okay, thank you. Can we turn to page 54 of the compendium, tab 6, which is the Saugeen surrender. Now, the Saugeen surrender is 1854. And I note that in the Saugeen surrender, we've got, I believe, a picture of the Saugeen Peninsula or the Bruce Peninsula at page 56
Yes.
of the compendium.
Yes,
Now, this is just, I've just taken a picture out of paragraph 13 from a court case that recently happened. Because I
yes,
just wanted to show the size,
yes,
give some perspective of Treaty 72 and what was surrendered in 1854.
yes.
And that was surrendered for proceeds, right?
That was surrendered for proceeds. Again, this is an apples and oranges comparison though, because this was, this tract of land had already been surrendered in 1836. And
Well, no, that hadn't been
And-
surrendered in 1836.
no, what was referred to as the Saugeen territory, it's Sauking. That tract had been surrendered, which is the entirety of that peninsula. However, a reserve that had been established in the white area that you see. So the area north of Owen Sound which is marked in light color here. That if you look at all the maps throughout the late 1840s, they all show that as a reserve. So that reserve was still there. Curiously enough, this whole original surrender of 1836 did not specify any annuities or any monies, any compensation whatsoever. And that was later fixed with a fixed annuity. And so there was actually, the Saugeen people were actually receiving a fixed annuity.
Do you see the area in Treaty 72?
Yes,
I'm going to suggest to you, sir, that the land surrendered in Treaty 72 of 1854 was not surrendered in Treaty 45 and a half of 1836. Do you agree with that?
I can only tell you what the Crown understood. And the Crown, whether it was or was not in fact surrendered is a legal question that the courts have to deal with. But what the Crown understood it to be was a reserve. It's not like the Robinson treaties that involved the extinguishment of Indian title. So this was a Treaty 72 surrendered a reserve. And as you can see in the wording of the treaty itself, it says a complete surrender unto the Crown of that peninsula known as the Saugeen and Owen Sound Indian Reserve. Right, so it's understood by the Crown to be a reserve. You cannot treat that the same way as you would a tract of land that the Crown thought still was encumbered by Indian title.
Okay,
Right.
so you say that the Saugeen Treaty Number 72, because they called it a reserve, was not Indian title. That's your view.
You know, they didn't understand it to be a tract of land that still was encumbered by Indian title that required a treaty that would result in an annuity payment.
Nonetheless, I'm not going to argue with you about the law. I think I'll do that somewhere else. You would agree with me that it's a large parcel of land that was given up by the Indians. I don't even want to use the word surrender. It was given up by the Indians to under Treaty 72 for proceeds. Yes.
Yes, and those proceeds were distinguished as land funds from what the Saugeen were receiving already in their fixed annuity.
Okay.
And
I didn't ask that question.
yeah,
I'm
so
not sure that that's responsive. Can we go to the next tab, tab 8? Sorry, tab 7, I apologize. Tab 7 is treaty number 94 in Exhibit 12 of Phase 1, which is the surrender of Manitoulin Island. And here, let's take a look. It's October 6th, 1862. We're at compendium page 57. And here we have another giving up of lands. I don't want to call it a surrender because I don't want to get into a debate. We have a giving up of land to the government under treaty number 74 or document number 74.
74 or 94?
94, thank you, I apologize.
Thank you.
94. Again, this is for proceeds, yes?
yes,
All right, and it's interesting, the third line of the document identifies that it was articles, it says it's articles of agreement between William McDougall, Superintendent General of Indian Affairs, and William Sprague,
yes,
Deputy Superintendent of Indian Affairs, on the part of the Crown.
yes,
So Sprague is familiar with a proceeds model in 1862, eh?
well, of course he is, because he's dealt with proceeds models and annuity models,
Mhm.
throughout his tenure. And
Right.
if again, if you look at the second paragraph, which you really need to read, it's quite plain that what they're talking about is a surrender of a sale of lands that involves a tract for which the Indian title had already been surrendered. It says, whereas the Indian title to said island was surrendered to the Crown on the 9th of August, Anno Domini 1836, under and by virtue of a treaty made and so forth. So it's there, it's the Crown's
Sir, do you want to
understanding.
continue reading? Do you want to continue reading what it was surrendered for? You're not being fair. All right, there's an objection that I didn't let you finish reading the paragraph. I thought you'd moved on. The record will show what it says, but you can read it. You can, if I interrupted you reading the paragraph, you can read it. I apologize, sir.
Yes, well, I just encouraged you to read the second paragraph. I mean, everyone has it in front of them. I don't need to.
Well, I'll read it then. It was surrender, Indian title to the said island was surrendered to the Crown on the 9th August, Anno Domini 1836, under and by virtue of a treaty made between Sir Francis Bondhead, then Governor of Upper Canada, and the chiefs and principal men of the Ottawas and Chippewas then occupying and claiming title thereto, in order that same might be made the property under their great father's control of all Indians who he should allow to reside thereon. See
Yeah,
that? The idea was all the Indians were gonna be moved to Manitoulin Island, right?
yeah, it was a crazy idea that Bondhead had, which proved to be which never materialized.
And so then we have Sprague and McDougall entering into an agreement in 1862 after this failed attempt, Bondhead's failed attempt. There's a surrender of all of Manitoulin Island for proceeds, right?
Yes,
Thank you. And I guess we can consult maps and see how big or how small Manitoulin Island is. The next, we're getting towards the end, believe it or not, I think. Would you accept, sir, that the Anishinaabe and the Crown were of the same mind in 1850, that the Anishinaabe would be in control of their annuity monies that were owing to them? On the RST side, I'm sorry, I should have clarified my
yes,
apologies.
I was just thinking, because as you know, on the RHT side, you know, it was managed differently than
Yeah.
on the RST side. So in respect to the RST, right from day one, in 1851, they were given the annuity per capita directly to the heads of families. So that suggests that control of that money was given to them to do as they pleased,
Yes.
which is different from the RHT.
But that's what the RST Anishinaabe wanted, and that's what the Crown was okay with.
Yes,
Thank you. Now, the next part of this discussion that we're having is going to involve looking at a fair number of documents. And I'm going to be right up front with you and tell you that I'm going to show these documents to you in the hope that you will accept that the Anishinaabe and the Crown were of the same mind in 1850, that large sums of money belonging to bands should be invested. I'm going to try and get you to agree that the Crown, after 1850, did not make any meaningful attempts to keep track of revenues and expenses from within the treaty territory. And I'm going to try and get you to agree that, save for the actions taken in 1875, the Crown's numerous complaints made by the Anishinaabe about the treaty, including the amounts they were to receive, were not acted upon. And I think you've actually already agreed to that, so I don't need to go into that. I can wipe that off of my list of questions. And the final thing that I'm going to ask, hoping to be able to get you to agree to, is that in 1873, it was Sprague who limited the augmentation request to $4, not the Anishinaabe. Now,
Your Honor, that was quite,
I'm telegraphing to the witness where I'm going.
I don't have a problem with it. It was just like quite a buffet of information. I hope that when the actual questions are asked,
Yeah.
he's not expecting even someone as like stuck about here to remember all of those conditions, that he will refresh.
Well, even if he did expect that of Dr. Von Gunn, he cannot expect it of me, so.
Yes, no. Look at,
So I think we're
I'm going to be quite candid here. I want to try and save time. I want to telegraph to this witness what I'm going to try and, not by trickery, but by persuasion, get this witness to agree with. And so I'm telegraphing to him where I'm going. All right. So the first place I want to start with how proceeds would be spent. And in your report at page 12, you make the point of saying that up to 1829, fixed annuity monies were just paid out to the Anishinaabe to do with as the Anishinaabe thought best, right?
Yeah, what I said is, as of 1829, excuse me, although the government controlled the funds, the First Nations had a voice in these disbursements and generally determined how the money would be spent. From time to time, or whenever they were required, applications would be made to the Indian Department to have certain amounts released for a variety of specified purposes or projects. And so that's the type of arrangement that continued with the RHT in the early years until
Right.
the mid 1850s.
Right, but we've already established not with the RST.
Yes,
But then at page 12, you also say, starting in 1930, the fixed annuity monies would be recorded in government books. And again, as you've just said, the First Nations would have a voice in those disbursements, right?
I'm just catching up. Sorry.
Okay, so
Are
we're
we
at page 12.
12 in the compendium?
No,
No,
I
in my
apologize. Page 12 of Exhibit 49, they're
Thank you.
just demands report. Yeah,
Okay.
I just wanted to correct you, Mr. Schachter. You meant 1830s, not 1930s.
thank you for that correction.
Go ahead.
Okay, so you set up the way things worked as to your understanding at page 12. And then at page, if you can go to page 21, you show how some of the annuities were used when they went into the annuity fund, right? This is a statement showing to whom the sum of
Yes,
£6,655 currency was used or what it was. And there's a little description about what the money was used for. You see that?
yes,
And so sometimes, and this is towards the bottom of this document, we can see that the money in the annuity fund would sometimes be used for industrial schools,
yes,
and it would be used for superintendent's salaries.
yes,
And it was under the control of the Governor General as head of the Indian Department at that time.
yes,
And when we get to the 1850 Robinson Superior Treaty Territory, the monies were not subject to the same restrictions that had been the case in the prior treaties, right?
In the case of the RST,
Yeah,
no.
thank you. Can you go to the
Could
compendium?
you tell me in this question that you're asking, the monies were not subject to the same restrictions set out
Oh, sorry.
in
The
the treaty
restrictions set
or
out.
in practice?
Yes.
Go ahead.
Yeah. The restrictions set out in 1830 about requisitioning and use of funds were not followed for the Robinson Superior Treaty Territory.
That's what I understood when you asked it the first
Thank you.
time.
Yes, my apologies for not being clear. Can we turn to tab 8, please, of the compendium, Exhibit Q? And we're looking at Treaty number 71 from 1853, dated January 19, 1853. It's part of Exhibit 12 of Phase 1. It's the Treaty of the Wyandotte Indians. And a couple things I want to point out on this. This, would you agree, is a surrender of part of reserve land? Would you agree with that?
Yes,
And if you'll notice there's a very large paragraph, and at the end of that large paragraph, 5 lines from the bottom,
yes,
it says, her heirs and successors forever, to the end and purpose that her said majesty, her heirs and successors may be graciously pleased to order. I want to pause. We're going to come back to those words. They seem familiar to me. And direct that the said parcel or tract of land be first valued and then disposed of by bargain and sale, and the monies arising therefrom to be appropriated to the use and benefit of the said Indians and for no other purpose whatsoever.
yes,
So the first thing is the use of the phrase graciously pleased to order in the way it's used in this document does not suggest that Her Majesty could simply just ignore the request to do what is asked of her. Would you agree with that? Her Majesty may be gracious, but she still has an obligation. Would you agree with that?
the intention was for Her Majesty to order and direct that the said parcel or tract of land be first valued and then disposed of.
And to do it in a gracious manner, I suppose.
Well, I think the intention was to have Her Majesty invoke the royal prerogative to direct that the said parcel or tract of land be valued and disposed of as stated.
Right. So do you think that the bargain here is to give to the Crown the option of just ignoring the request to value the land and dispose of it, or is it an obligation of the Crown to do so under this document?
Well, it's an obligation, obviously. But like all of these land surrenders and treaties as well, ultimately, it's still up to Her Majesty to confirm this. I mean, the representatives on the ground obligate the Crown, but they still have to leave it to Her Majesty to ensure that it's done.
Okay, fair enough. The point is that what's happening here, the bargain, if we can call it that, is that lands are going to be valued and the proceeds are going to be disposed of to be appropriated to the use and benefit of the Indians.
Yes,
And so there's nothing here about putting the money in the government trust accounts just to be appropriated. Right?
yeah, we would have to look at the actual books to see where that money actually went and how it was administered. And my guess is, from knowing those records, that it was administered much like all the other land funds.
Right. It may have been, but that's not what the document says.
That's correct.
Right. Let's go to treaty number 75, because we're trying to figure out what the purpose of these questions is, to try and look at examples of what the Crown and the Anishinaabe, or the surrendering Indian, the Indians who surrendered the land, what they were thinking when they made the bargain. Not what happened afterwards, but what they were thinking. And would you agree with me that looking at the document of surrender or is helpful to trying to understand what the intentions of the parties were. I hope you can agree with that.
Well, often we have little else.
Yes, but it's helpful.
Yes.
All right, so let's go through the next one. The next one is treaty number 75. Again, it's 75 in phase 1, exhibit 12. It's at page 61 of the compendium. And this happens to be the surrender of the Michipicoten Reserve in 1855. You familiar with this one?
Want to make sure it's the same one. I refer to this and discuss it at pages 115 to 116 of my report. That's the section where I talk about the various agreements of this type. Under the these are all relate to the Robinson treaties. These are reserve surrenders.
Yeah.
Yes.
So
So
my point is,
yes.
I want to look to see what the Crown and the Anishinaabe thought the proceeds, where they would go, how they would be used.
Yes.
And here, the Michipicoten and RST bands ask that the proceeds are to be sold. And then, and here I'm on page 62 of the document, in the first paragraph, just before in testimony whereof, if you go up 4 lines, starting with Queen Victoria, it says, in trust for the purpose of being sold to the best advantage, and the proceeds thereof to be invested in such a fund or funds as the Governor General or other person administering the government of Canada for the time being may direct, for the use and benefit of me and my people and our posterity. See that?
Yeah.
Now, this surrender, or whatever document you call it, because it's only signed by the chief, and I guess John McCary, I don't know who that is. Do you know who John McCary is?
No, I don't.
Okay. It looks like the chief is trying to surrender it for his whole community, but in any event, do you know what is meant by the use of the phrase from time to time? I mean, we're in 1855, and who is administering the government of Canada in 1855?
So this is still the Governor General,
Yeah,
and because it's prior to the 1860 transition to the civil government of the province.
right. Do you know what the reference to time is? Because it just seems out of place temporally. Right? I mean, was there any thought in 1855 that the Governor General wasn't going to be in charge of administering Indian affairs in 1855? Is that why?
I'm sorry, where do you see time to time?
It's right on the portion that I read, and it's on the screen in front of you,
Oh, I see.
2 lines above in testimony whereof. We have a little cursor flying
Yes.
around.
So we're saying for the time being.
Yeah, I'm just wondering if the
Yes.
time being is that what's intended here is that it would be invested by the Governor General for the time being, but that something else would happen later, or is it dealing with two different bodies administering the government? I'm just wondering if you can help me with the confusion. I've been
Yes.
having.
So for the time being, they are assuming that the immediate responsibility will be the Governor General, but that may change. I think they're just basically saying it's not necessarily that the Governor General does it into perpetuity. But
Right.
for now, you know, it's under the Governor General's auspices. And of
Right, and
course,
they-
he's not doing it himself. He's got underlings. to
Right, of
do that.
course, of course. And indeed, the Indians might want to administer it themselves later.
That's not the way these things worked. You know, when I discussed this at pages 115 of my report, I gave several examples. This is just one language. There are many other
Okay,
of these.
well, I'm just looking at this one though.
Yeah, so they vary, but so what happens now? I mean, Titimane, the chief who has signed with his totem on this document, later appears in the actual accounts under, and has a land fund just for his people, where these sums are administered. And you may recall that, you know, when I showed you these lists of schedules, he's one of these.
Dr.
who-
Von Gernert, I'm not debating with you that the monies ended up in the land fund.
Yes,
I'm not challenging that. I'm trying to understand what was understood in 1855. Right, and I don't see that there's a, when it says invested in such a fund or funds, that suggests that there's some expectation that someone's going to be looking for the best investment. Would you agree with that?
no, these are now being administered by the Receiver General, who's investing the proceeds at the standard rate. That's in practice what actually happens. What the intentions may have been, I can't really speak to that.
Okay, that's fine. If you can't speak to it, that's the end of my question. I was asking you about the intentions. All right. Let's go to the next petition, which is number 92, which is the Fort William surrender of their reserve in 1859. It's a compendium page 63, treaty number 92 of exhibit number 12 in phase 1. And here we have a surrender to by Fort William in the second line to our gracious mother. So they're looking at her mother graciously, I guess. And then you have the purpose in the paragraph, the second paragraph, or let's go to the bottom of the first paragraph,
Just to be clear, is this tab 10, page 63?
tab 10, page 63. Yes.
Thank you.
The last three lines, starting with about 5,000, the sentence at the end there, at the end of the third last line, to have and hold the said parcel of land and premises with all its appurtenances unto her said majesty, her heirs and accessors forever, for the purpose of being forthwith surveyed and sold for our use and benefit. And then it continues. And we further agree that the proceeds from the sale of the said land may be invested in good securities in order for the interest arising therefrom may be paid to us and our posterity annually forever. You see that?
Yes,
Now, they don't mention the land fund, they mention good securities. See that?
Yes,
Does that tell us something about the intention of the Fort William Anishinaabe? That they're looking for good securities?
no, I think what this passage suggests is that this is going to be handled the same way as all of the other land funds. And that's exactly what happened, because the land funds in and of themselves are invested by the Receiver General.
Yeah.
And I'm not sure what kind of securities they're talking about, but the, you know, I don't know what, I mean, I don't know nothing about, you know, how these funds are actually invested. I only track them. And in the tracking process, you notice that they accrue interest. Whether it's at the best possible advantage or not, I can't say, because I don't know how they were actually invested in a bank. But they are certainly tracked. The interest is tracked, the proceeds are tracked. And so I think what is being communicated here is that whatever proceeds there are going to be put into your land fund, which will be invested.
I'm sorry, sir, where in treaty number 92 do you see the words land fund? I see the word invested in good securities. I don't see the word land fund.
Well, it's maybe paid to us and our posterity annually forever. So it's got to be somewhere in the government accounts. It's not like they're opening a bank account for the First Nation, right? It's the government that's paying them from the land funds. There is no other fund. I mean, I can't
Well, no,
imagine.
it ended up being that there was no other fund. I accept that.
Yes,
But that's not what the treaty says. I mean, if we're trying to understand the expectations and understanding of what the Anishinaabe wanted, never mind what the Crown did with it. In trying to understand what the Anishinaabe wanted, I'm suggesting to you that it speaks for itself and they wanted it invested in good securities. Doesn't go further than that. Would you agree?
well, this is the promise that was made, yes.
And I note that they want the interest from the securities to be paid to us and our posterity. That almost sounds like it's an endowment fund. Have you ever heard of that word before?
Yes,
Is that a fair characterization that what they're trying to set up here is an endowment fund?
I don't know whether they had an understanding of what an endowment fund was or how, if in any way it's differed from a capitalized fund or any of that. One of the points that I made in my report is that the actual accounting of this was poorly communicated to the Anishinaabe. That said, this is not the first time that they've seen such an arrangement. I mean, these land funds have been going on for generations by now. And even though they themselves may not have been exposed to or enjoyed receiving the proceeds of such land funds, they surely heard about such funds from their kin who did have them.
Final question about treaty number 92. I note that the signatories include a Christian chief and a pagan chief.
Yes,
Looks to me like they had a common intention, even though one's a Christian and one's a pagan. So that's a good example of people working together with different religions. Yes.
yes, although it happens that this is probably not a very good example because Illinois didn't always get along with some of the others. There were always tensions between the so-called Christian chiefs and the so-called pagan chiefs. These are obviously not self-ascriptions. And there was even at one point a claim that Illinois' signature had been forged, which was not easily proved since he only used an X.
Well, it is easier to forge an X than a signature, isn't it?
That's true.
All right. There are a couple of more documents I can go over before 1 o'clock, or I could break now. What is the court's preference?
Do you think you'll get there by one? You'll finish by one?
Over a couple of documents, yes, I think I can make use of 4 minutes of time.
Okay,
All right, so we're going to move to a different area now, Dr. Von Gernert. We're going to move to an area that I'm calling the lack of response to concerns raised by Anishinaabe. And you've already sort of given an indication that where there were requests for more than $4, they weren't responded to. But I wanted to just deal with a group of other petitions that weren't dealt with, whether it was for $4 or not. First one is the 1852 petition of the Fort William First Nation. And here they are very much disappointed in the treaty annuity. Is that fair?
I'm sorry, which tab?
I apologize, tab 11 of the compendium, page 65.
Yes.
And what they're complaining about is the smallness of their annuity that they received in 1851.
Yes.
And this petition, there's no record of it ever being responded to.
Yes.
Thank you. Let's
sorry,
go-
and what can we call this document, or what has,
It's
have
the
we called it before?
It's the Fort William petition,
Huh.
January 3, 1852, trial exhibit, phase 1, 0955.
Thank you.
Now, just to be clear, can you go to page 66 of the compendium? The third father, there's a reference to, towards the end, we thought, according to what you told us, comma, that you would look after the interests of your children. And still today, we see that little that we have said was, and still today, we see that the little that we have said was not heard. See
Yes.
that?
Yes.
Now, looking after the interests of the children sounds very much like tracking Dr. Dribbin's theory about wanting the best for themselves. Would you agree with that?
Yeah, again, this is the original of this was written in French, and
Yes.
which means it probably came from Shoney.
Yes, there's no dispute that it did come from Shoney, and there is a original French at exhibit 0955, and you can compare the two if you like. I believe the only difference between the two is in English, there's they reference pounds instead of piasters.
Right. Yes, no, I'm not questioning the translation.
Ah, thank you.
And what I am suggesting is that one of the things I've learned about Shoney is that, when he's writing this, he may well be interjecting a great deal of his own expressions. And I think I touched on this when we
Yes.
talked about red children and that sort of thing.
So he's the same fellow that did the 1873 petition, February 12, 1873, that was acted upon by the government.
Yes, the one that was accompanied by Dawson's covering letter.
Yes, okay,
Yes.
maybe that's a good place to break for lunch.
All right, we'll break then for lunch. Go off the record, please. And